Thank you.
Lord, I have to make another request, my Lord.
Yes.
Lord, we the lawyers, this side or that side, that apart, Lord, a much bigger responsibility lies on our shoulder, not to give it a color of any religion. And let us restrict our argument only with regard to, my Lord, what is there in the rule book or in the constitution. That's the only request, Lord. And one more, Lord, submission is this, Lord, at the very outset. Lord, we have filed an intervention application on behalf of Lawyers for Just Society.
Yes.
Lord, I don't know whether if your Lordship have received, because we have filed it online. If your Lordship could be kind enough to get, my Lord, and a compilation of judgment as well.
Lords, I am on my legs. All these intervention applications cannot, my Lords, can be heard, my Lords, at the appropriate time. My Lords, I was making submissions.
We have not received any such application till now.
Mr. Amrutesh is, my Lord, there in the courtroom. Our counterpart, my Lord, in Bangalore.
They may file it. They may file it in the counter. There is an urgent counter where they can file the application, and that will come to court.
That has been done.
Yes, Mr. Kumar.
That's a very important submission. I request the court to kindly.
Please open the mic. Mic is. Yes.
They are making two applications.
Making applications, all have to be filed in the counter, not in the court. We have stopped this practice.
No, with great respect. Urgent application is for this purpose.
All urgent application, there is an urgent counter in the registry where you can file the urgent application. They will be same day sent to the court.
Very well. That event may make some.
We are unable to hear. Yes.
Lords, may I resume, my Lord?
Just a minute. Some senior advocate is making a request at the dais. Yes.
We have already furnished a copy to.
All right, you file it in the counter. Tell them the matter is listed today. They will send it to the court.
And all that I praise. We take some time of getting instructions.
Let it come before us. Let it come before us. Yes. Yes.
Yes, may it please, my Lord.
Mr. Kamath.
Yes, my Lord. May it please, my Lord. My
Yes.
Lords, your Lordships were kind enough to give us almost 2.5 hours, my Lord, on Thursday. My Lords, I was making submissions on this GO of 5th of February. And my Lords, I had, my Lords, broadly submitted that this application, this GO, my Lord, suffers from a total non-application of mine, number one. And number two, my Lords, that this GO is in the teeth of Article 25. Now, my Lords, if I can invite you to kindly go back to the GO, because I had very little time on that day to actually place the entire GO.
Yes.
That translated version of the GO can be just placed.
Yes.
Where is the translated version of the GO?
Yes, my Lord. As mentioned in the above at reference number 1, the Karnataka Education Act 1983, passed by the government, stipulates that all school students studying in Karnataka should behave in a fraternal manner, transcend their group identity, and develop an orientation towards social justice. Under Article 130, Section 133 of the above law, the government has the authority to issue directions to schools and colleges in this regard. Above mentioned circular at reference number 2. Kindly see this, my Lord. This is a circular of 31st of January 2014. Underlines how pre-university education is an important phase in the lives of students. All the schools and colleges in the state have set up development committees in order to implement policies in line with the policies of the government, utilize budgetary allocations, improve basic amenities, and maintain their academic standards. It is recommended that the schools and colleges abide by directions of these development committees. As such, supervisory committee in schools and colleges SDMC, government institutions, parent teachers institutions, associations in the management in private institutions should strive to provide a conducive academic environment and enforce a suitable code of conduct in accordance with the government regulation. Such a code of conduct would pertain to that particular school or college. Various initiatives have been undertaken to ensure students in schools and colleges have a standardized learning experience. However, it has been brought to the Education Department's notice that students in a few institutions have been carrying out their religious observances, which has become an obstacle to unity and uniformity in the schools and colleges. The question relating to a uniform dress code over individual dressing choices has come up in several cases before the Honorable Supreme Court and High Court, which have ruled as follows. So 3 decisions are cited, my lord, and I'll come to it specifically, but I'll skip it for the moment. And then, my lord, the next page, the conclusion which the government assumes flows from these decisions is, as mentioned in the above mentioned rulings of the Honorable Supreme Court and High Courts, since there is a prohibition of headscarf or a garment covering the head is not a violation of Article 25 of the Constitution. Additionally, in terms of the Government Education Act 1983 and its rule, the government has decreed as follows. Over the page, my lord. We are really not concerned with government schools in my petition, but I'll read it in the backdrop of the issues highlighted in the proposal. Using powers granted by the Education Act, Section 133(2), all government schools in the state are mandated to abide by the official uniform. Private schools should mandate a uniform decided by their Board of Management. In colleges that come under the Pre-University Education Department's jurisdiction, uniforms mandated by the College Development Committee or the Board of Management should be worn. In the event the management does mandate a uniform, students should wear clothes that are in the interest of unity, equality, and public order. So, my lord, 2 things which the GO says in substance is, number 1, wearing of headscarf is not protected by Article 25. Specific finding, a declaration made by the state government. Number 2, we leave it to the College Development Committee to decide whether these uniforms should be uniform or some exemptions can be made. College Development Committee. Now, my lords, on the first aspect, I respectfully submit that this declaration, which is there in the penultimate page of the GO, that wearing a headscarf does not fall under Article 25, is totally erroneous. And I'll demonstrate and make that good. Number 2, as far as this delegation to a college development committee to decide whether to permit students to wear a headscarf or not, that itself is totally illegal, because lordships are aware that under Article 25, the only restriction which probably comes to the aid of the state in restricting that fundamental freedom is public order. Now, public order is a state responsibility. It is a responsibility of the executive. Lordships are aware. Entry 1 of list 2 of the 7th schedule, item 1 itself, public order, it's state's responsibility. The question which will arise for your lordship's consideration is, a college development committee consisting of some MLA and subordinates will today decide whether exercising this fundamental freedom under Article 25 is permissible or not. They have been a third party, an extra statutory authority has been made the guardian of Article 25, which according to me under our constitutional scheme is totally impermissible. So, my lord, these are the broad, my lord, arguments which I want to make as far as this GO is concerned. Now, my lords, kindly have first, my lord, Article 25. Lordships have seen this time and again, my lord. But for my satisfaction, if your lordships can just have Article 25 again. Conscience and free profession, practice and propagation of religion, subject to public order, morality and health, and to the other provisions of this part, all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion. So, my lord, as far as this case is concerned, we are not concerned with morality, my lord, or health. So the only restriction which probably aids the state, as far as this freedom is concerned, is only public order.
Question is whether this right conferred under Article 25
yes, my lord,
is absolute.
Yes.
Whether it is an absolute right or a relative right.
Yes.
Subject to certain restrictions.
Yes, I bow down to that, my lord. That's really the heart of this question. Lordships have put the, my lords, hit the nail on the head. And, my lords, the answer is 2 or 3-fold. Article 25 rights, my lord, are not subject to general reasonable restrictions as under Article 19. The restriction on Article 25 is envisaged in Article 25 itself, and that is public order, morality, and, my lords, other provisions of this part.
Article starts with the word subject.
Yes, correct. I'm grateful.
What does it mean?
Yes, I'll explain that, my lord. I'll explain that, my lord. Lords, as I, my lords, develop my presentation, I will show, my lord, that public order as a concept which your lordships have evolved is, my lord, not a mere law and order disturbance. As your lordship's court have described, my lord, that law and order, public order, and security of state, these are in concentric circles. And therefore, my lord, a public order issue is a higher form of, my lord, a law and order issue. Now, my lords, when we are actually seeing whether a particular practice, my lord, disturbs public order, there are several facets to it. And one of the facets which your lordships will consider is whether the practice by itself leads to a problem of public order. Now, my lord, there are practices, like, for example, in that...
What is public order? What is... Please...
Yes, my lord. I will come to
light on the public order. What is what amounts to public order?
Yes, my lord. My lord, where there is a heightened sense of, my lord, law and order issue, definitely, my lord, it will be an issue of public order. And, my lord, the